They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
That's like the last case you were here on. Now we have a problem because if that money doesn't appear.
One of the most important concepts they teach in law school is optics. What things look like aren't always what they are. That cuts both ways. This lawyer took her client's rent money and escrowed it into an account. Her own account. That's a problem, because even if she didn't mean to steal the money, it sure looks like she could have. It doesn't help that what she's doing with the money in that escrow account is absolutely illegal. Judge Simpson hates this lawyer, and I can't believe she's still barred. He's called her out for similar questionable behavior before, and this time it's worse. I'll follow up with any disbarment hearings she faces. It's gonna happen sooner or later. Let's roll notes.
Fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing. Okay.
Donna Toth, appearing on behalf of Eric and Aaron Ward, the tenants on the lease.
All right. I'm almost afraid to ask, where are we?
Your Honor, I believe procedurally we're at this would be the first pretrial hearing because the first hearing was adjourned because Ms. Toth was out of town.
Yes.
Well, I didn't sign the order, but it was adjourned. However you want to look at it. Yes, procedural. Go ahead.
Your Honor, tenants Erica and Aaron Ward own and operate a horse boarding farm on the property. Under the lease, tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlord. Tenants are operating their commercial horse farm rent-free on the property during the pendency of their circuit court action. Tenants admit to withholding rent, so there's really no factual dispute here. Right now, I believe the base rent owed is $24,800.
24,800.
Yes, $24,800. Or if you want me to get into the procedural history, because there is a circuit court action that was filed.
Well, I was just going to ask about that. Go ahead. I'll get back to you. Let me just. What about the circuit court action?
Your Honor,
is it between the same parties?
It's between the same parties with an added party, Willow Ward Equestrian, which is the business that operates on the property.
Got it.
That is the horse boarding farm that the tenants own. So in June 13th, on June.
Can I just ask?
Yes, Your Honor.
What is the general subject matter of that circuit court action?
The general subject matter is they filed the complaint and they're alleging that landlord, my clients, didn't make certain repairs on the property, and we dispute, the obligation under the lease agreement. But they're still not paying rent. And under the lease, it has that without any deduction or set off whatsoever. So they brought these claims. It was a race to the court, and tenants filed a circuit court action. And then we were forced to answer and counterclaim for breach of the lease agreement, breach of the guarantee, and we brought a tortious interference claim because tenants have been preventing my client from selling the property. My client's been trying to sell the property, and given their operation on the property, that's been an issue. So we've gone all of this time where tenants are operating on the property rent-free, and my client has his own financial obligations that he's not being paid for, but they're still operating on the property. And just because they filed a circuit court action does not insulate the tenants from defaults under the lease, and also doesn't bar this court from exercising jurisdiction over a summary proceeding.
So Donna Tope here. Your Honor, I know that you are a very thorough judge, and I filed an answer to plaintiff's complaint to recover possession of the property. Thank you very much. And in that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court that is being heard by Judge Outside. In my answer, I stated that the defendants leased the property at Delphi in Scioto Township, Ann Arbor, Michigan. The lease began May 1st, 2021 and ends May 1st, 2028. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. It has had an indoor arena, showing arena. It's a showing boarding facility. When Fixing Housing lease purchased the property on a land contract from the former owners, the lease with the wards continued that operation, it operated as a horse farm. So this is a little different than most landlord-tenant cases, Your Honor, because while Aaron and Erica Ward are the tenants, the place needs to be made healthy, safe for the welfare of not only the residents and the people who board their horses there, but also their horses. They have over 35 horses. So those are the beneficiaries of the landlord's duty to keep the premises under safe repair. About a year and a half ago, Erica notified the landlord that several of the outdoor sheds that shelter the horses during snow, sleet, the torrential rains we have 24/7 had deteriorated to the point where they fell down. A windstorm blew several of them down. They were no longer sheltering the horses, and the debris left by the destruction of the shelters was unsafe for the horses in the pasture. Erica Ward notified the landlord, asked for repairs. He did not respond. He also then went into the pastures because he has had it on the market. In the lease, it says that that it's invested, and he wanted to be able to show potential buyers and host events at the property, which he has not done. But he was looking for septic fields, and he had a bulldozer enter every pasture and dig with a bulldozer down 2 or 3 feet to see if the property perked for septic fields for development. It did not. He did not repair those. That is unsafe footing for the 35 horses that have to be out in the pasture 24/7, and they need safe footing. What started this current action, she also asked him to repair several other things. But what started this entire action was about June of 2025, the spigot, which supplies water for the horses, and they need a lot of water, needed repair. It was leaking, and it was going to burst and be unfunctional. She asked him to please make the necessary repairs. He did not make the necessary repairs. Aaron and Erica made the repairs themselves. They also, the hot water heater that provides hot water for the horses to be able to have their poultices for injuries.
But all of this is a result, it was in the circuit court action, right?
Yes, but it's under breach of the lease. And so what started this was that they asked for the hot water heater, which had failed. They asked for the hot water heater to be replaced. It's necessary for the safety of the horses.
But what about the provision that the base rent is going to be paid without deduction?
So that is if they live up to all of
Is
his
this
responsibilities.
conditional? That's not what I read.
Well, it is not conditional, but in any contract where one party breaches several,
I have two businesses in essence that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading for contract. Maybe if it weren't two businesses operating at arm's length, you might be correct, but that's not what I have.
no, we have a lease, and under Michigan landlord tenant law, which I have researched with the Michigan State University Law School and the University of Michigan, the city of Ann Arbor.
Law school? They have one?
They absorbed.
I dig it, I'm sure.
Okay, well, they do have one, and they give really great advice to their student tenants. And one of them is that if necessary repairs that affect the habitability, the safety, the welfare of the residents who are under that umbrella.
Where is that base rent?
So in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty bound to provide under the lease, and gave it to him. He then,
That's June.
that's June.
Okay, what happened in July and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July.
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the
Why
repairs.
can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Like the last case you were here on, now we have a problem. Because either you're going to be a witness or you're going to be a party to this. We ran into this the last time you had a case before.
Your Honor, I was their attorney, and this was the only way to be able to get the repairs done that had been necessary and posing danger to the horses, the residents.
You're playing, it's one thing if the attorney is using their trust account to hold funds of their client, right?
Yes,
These were not client funds.
yes. They were the client funds that were to be used to make the repairs for the lease.
Counsel.
In my answer, I have asked that you escrow, the rent was paid with a minor amount withholding that was still a balance due on repairs. The rent was paid this past month, and in my answer, I have asked you to set up, I've asked you to stay the eviction. I've asked you to escrow the rent under the same way you did in our other case. And I've asked you to transfer the case to the circuit court.
Not happening.
Your Honor, their notice for possession and eviction is exactly the counter complaint that they made to Judge Aldzai several months ago.
That's because you filed there.
I understand, but it's the same for judicial efficiency.
Too late.
It's the same circumstances. It's the same claims. It's the same.
May very well be, but that's for the court to decide.
Okay.
And I'm declining to do what you're asking regarding this case at this time.
You mean to transfer it?
I want to know where the escrow is.
The escrow is in my it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's
Counsel, do you
rent.
see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
no.
You took client money in
I withheld rent.
and then dispersed it.
I withheld rent under the landlord tenant.
But you can't on your own then disperse it.
They
If
dispersed.
they Miss Toe,
Erica Ward signed those contracts and paid those
Miss
contractors.
Toe, if as a tenant they elect to set up an escrow account to put their rent into, show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it.
My first request was that you stay the possession,
This case.
repossession in this.
Denied. Next request.
Motion for you to set up an account for the rent to be escrowed into and paid out.
I am not going to have a problem ordering escrow.
Okay,
What I am going to have a problem with is that I think because of what you just explained to me, that you are a necessary party that has to be joined. Because if they set up their escrow account with you,
no, they paid the rent to me. I did not really, there's no formal escrow account. I held it so
Well,
she could
well,
pay.
then that's another problem.
Oh my goodness. Oh,
Yes, oh my goodness, because the law has to be followed. They can't just give the rent to somebody else. If they're going to properly withhold, and I would have hoped you would have informed them of this, they have to set up an escrow account. Outside of the fact, then, they are really obligated to then let the landlord know where that escrow is.
I
And
did.
they are. But then they can't disperse it.
How can they pay for the necessary repairs that he did not perform over a year and a half?
File suit and get an order. And the fact that you're a party to that, I think it's going to make you a party to this action, because if that money doesn't appear, I think, I'm not suggesting that it occur, but I think plaintiff has a claim as to you because you had to take that rent as an attorney, as an agent, whatever. You took that in trust. It's like if they had decided to withhold rent and they went like most people would if they're going to do this, they go to a bank, they set up the escrow account. The bank can't then, if it's set up as a true escrow account, they have to direct that it's paid out. But that's not what's happening here.
Under landlord-tenant law, tenants are allowed to withhold rent. They don't necessarily have to set up an escrow account. They just have to inform the landlord where the money is, where the money
I
is held.
appreciate you giving me a lesson on landlord
I'm not
law that
giving,
I've been doing.
I'm not. I read the Michigan state law about tenants and what to do about landlords who do not make necessary repairs for the health, safety, and welfare of their tenants, which in this case includes horses and boarders. I also did file suit. We filed suit in circuit court for breach of lease, for every single breach of lease that the tenant has performed over the last.
Is there anything else?
No.
Because you're not listening to anything I'm telling you.
I am hearing you.
You're not listening.
I am listening, and I'm giving you an answer when you say you file suit, and I tell you that I did. We did file suit. No. Do you want anything else from me? Do you have a?
I got a ton of questions, but I never get an answer. So you can have a seat. Anything else in the plaintiff?
Your Honor, I would just say that the withholding of the rent is against the lease agreement, and placing in the attorney's escrow and paying contractors and paying for supplies at Lowe's and Home Depot is completely, it's wrong. And what I put in the motion to compel payment of rent is that the case law, we're disputing, and we filed an answer disputing that, we're on the hook for some of these repairs, but longstanding Michigan common law provides that tenants' duty to pay rent is independent of the landlord's alleged covenant to repair in the commercial context. And that's the Rheum case from the Michigan Supreme Court, and Detroit Marine Terminals is an unpublished.
Yeah, but statutorily that's been changed. So I understand the common law rule.
In the residential context, Your Honor.
I see what you're. Go ahead,
Your Honor, and that's all I have, unless you have any questions for plaintiff.
Is there another hearing set before Judge Outside?
Yes.
What day?
On November 7th.
I believe it's Wednesday. This upcoming Wednesday.
This coming Wednesday.
The basis for the termination in this case is really breach of their obligation, in a lot of ways the obligation to pay rent in this case. I think, as I was trying to point out there, as this court views it, additional problems and concerns regarding the use of this money. So what I am going to order, which is also unusual to order these cases, but I will order it, that the defendants are to provide to the court an accounting of the escrow paid into whatever the account was and the disbursement. Yes, Ms. Toe.
Your Honor. In my answer to plaintiff's complaint to recover possession of the property and my motions to eviction, motion to transfer case and proposed order proceeding, I explained everything and I included as the very last page, which was exhibit, I can't read my own writing, B2, and accounting.
Which one was it?
That was defendant's answer to plaintiff's complaint was filed on October 24th. They got a copy. The last page of that entire filing is an accounting of expenses paid.
Are the receipts attached?
I can get the receipt.
I want the receipts attached. I want a very detailed accounting of what came in,
Yes,
what was paid out.
yes.
I want receipts for all of those transactions.
Contracts, we have paid receipts. And an explanation of everything that the money went for.
Are you done now?
And the term of the lease under which that expense was made.
Are you now done? Yes. So I want that accounting. I am also going to order, how much is the base monthly rent?
$5,500.
Per month.
Per month. Was November paid to you?
The check was sent.
When was the check sent?
The check was paid out of Bank of Ann Arbor's bill payer on the first of the month.
And at this point, you haven't received a check. Give me 55 divided by 4 times 3.
Divided by 4
Times 3, yes. 41.25. I'm going to order that the defendants are deposed with the court within 7 days. Escrow for November prorated in the amount of $4,125. And then are deposed with the court $5,500 on the first of each month, and that rent ordinarily would be due. How long will it take you to get that detailed accounting to me, Ms. Tope?
I'll have it to you tomorrow, Monday.
You've got a hearing before Judge outside next week.
Wednesday.
So I will then adjourn these proceedings, see where that has gotten to November 21st.
Is that before Thanksgiving? No,
It is.
it is. Is it the Wednesday before Thanksgiving?
Thanksgiving is on the 27th.
Your Honor, I am scheduled to be out of town with my family and relative in Portland, Oregon,
What days?
from the 20th to December 3rd.
Then fine. Then fine. We'll see you next Friday.
Next Friday.
Yep, the 14th. At what time?
2 p.m.
2 p.m. in person. All right, by that time, the escrow, at least the first payment of the escrow should have been paid or some verification of the receipt, and then we will go from there. Thank you.
Thank you, Your Honor.
Thank you. Thank you.